ask you questions as well, but we understand you guys are all busy practitioners and have places to be. So with that said, the first case that we are going to hear today is Carla May St. Angelo versus Jennifer St. Angelo Hughes and Christopher St. Angelo, and it's 25-1398. As counsel is aware, each side gets 20 minutes. Counsel for appellant, would you like to save your time for rebuttal?
I would.
Is 5 minutes?
5 minutes is exactly what I was thinking.
Okay. Whenever you're ready, counsel, you may proceed.
Thank you. Good morning, and may it please the court. My name is Bob Goldman, and I represent Carla Santangelo, the decedent's surviving spouse. As we reserve the 5 minutes, I also want to indicate to the court that we rely on our initial and reply briefs in addition to our brief dialogue today. The broad issue in this case is whether my client can seek a determination of estate assets, and that depends wholly on her standing as an intestate heir. That issue has been decided in her favor, being a surviving spouse and having an intestate share as a surviving spouse in 5 different final orders in this case. The original order on the petition for reformation, the amended order on the petition for reformation, which found its way up to this court in 2023, an order on rehearing of that amended order that was never appealed, and an order on the petition for family allowance and exempt property, where part of the antenuptial agreement was interpreted, including the part where the court found that she was a surviving spouse and had an intestate share. The 2 final orders under review stem from 3 petitions that my client identified, that are identified in those orders, and they basically pertain to the nature of the assets and her entitlement to them, and whether she has a financial obligation with respect to those assets. My client timely noticed those petitions expressly for an evidentiary hearing, but that never happened, and in part because the court hearing those petitions was a new judge to the case, and understandably, I think, wanted to understand the history of the case and the extent to which his jurisdiction was limited as a result of prior rulings of the predecessor judge.
Counsel, as to your argument regarding the requirement to have an evidentiary hearing on the issue, can you elaborate for the court what evidence you would have introduced at an evidentiary hearing?
Sure. Taking just a couple of examples on the petition to determine assets, that involves a business known as Seminole Prairie. Is Seminole Prairie a separate entity, or simply part of another entity owned by the estate called Okeechobee Outfitters? So all of that needed to be considered. Also, the son of the decedent claimed that entity was, if it's an entity, was in fact gifted to him prior to death. So Florida corporate documentation from the state of Florida, evidence of a gift or not a gift, tax documents showing the Seminole Prairie assets as being part of Okeechobee Outfitters, testimony of the CPA that dealt with financials related to those businesses, and testimony by my client, the manager of Okeechobee Outfitters. That's one example. With respect to the petition related to the mortgage on the property and the note, that involves, of course, those documents and the history of those documents, because they changed the nature of the title on that property, what that debt was used for, in fact, and how the mortgage was paid, and again, state court documents, tax documents, financial statements of Okeechobee Outfitters, and my client, again, as a manager, and what was intended by the creation of that debt. She was not on the title to the property. And also testimony of the CPA and the decedent's son on those issues. So those are examples, Judge.
Thank you. Did you need to make the trial court aware of the reason you needed an evidentiary hearing and what you would hope to do with an evidentiary hearing after they proceeded without one?
I don't think we were in a position. The trial transcript is very short, easy to get through, and I think, anyway, it's crystal clear about what he wanted, which was, in fact, an understanding of the history and our observations of prior orders and whether they amounted to and bound him as the law of the case. We understood it was going to be bifurcated. We weren't objecting to that. That simply made sense. So there was no position in that proceeding. We thought we were going to an evidentiary hearing afterwards. What we got was final decisions as though there had been an evidentiary hearing. So there was, at no point in that was there something to object to, something to proffer. We were waiting for an evidentiary hearing, and in fact, and it's in our appendix, the proposed order we sent in at his request, again, contemplates that there will be an evidentiary hearing subsequent to the court's review of the memorandum and deciding on the limitations, if any, to its jurisdiction.
Counsel, does any of that evidence that you weren't able to put on, does any of that matter if, apart from the legal determination that Ms. St. Angelo is entitled to an intestate share? In other words, if she's not entitled to an intestate share, does any of that evidence matter at all?
It really doesn't. I mean, that's the whole point, is standing is everything in most proceedings and this one as well.
So can you just kind of pinpoint for us, I understand your argument is that the legal determination that she is entitled to an intestate share is law of the case at this point. Can you pinpoint for us where that determination became law of the case such that it could not be departed from afterwards?
Sure. I can, and if you, when you're thinking through the case, if you go to my appendix at pages 18 through 34, you'll have those orders. But to answer your question directly, when this court affirmed everything but the appointment of a personal representative with respect to the amended order, that became law of the case on that issue. But actually, before that even, it became law of the case because the order on rehearing, where the court clarifies and makes clear this is an obligation of the estate, this is her entitlement to this share as a surviving spouse, was never appealed. And then again, on the order determining the exempt property and family allowance, as part of, correctly, I think, as part of an interpretation of paragraph 3.07 of the prenuptial agreement, the court goes through and makes findings about her intestate share, as well as deciding that's one thing she gets, but what we take it away under 3.07 is her right to exempt property and family allowance. So in those two cases, neither one being appealed, those became law of the case within this court's order also.
So, counsel, in your brief, you cite the case law, DCA case law, to the effect that law of the case would include issues that could have been taken up on appeal but weren't. I think that would, that category would include the rehearing motion that wasn't appealed, and it would also include, I guess, within the order that was taken up on appeal, issues that were not raised to the 6th DCA. But I look at the Giuliano case out of the Florida Supreme Court, the 2001 case, and to me that case rejects that concept and says, I'll just quote from it, the law of the case doctrine is narrower in application in that it bars consideration only of those legal issues that were actually considered and decided in a former appeal. Mm-hmm. So when we look at what was actually considered and decided in the appeal to our court,
sure.
Can you pinpoint for me where in that decision and what we actually decided would establish law of the case on that issue of the her entitlement to an intestate share?
And all other findings we affirm is what this court said.
But wouldn't that matter? Wouldn't that still be limited to what they raised in that initial brief? So,
No, respectfully, Judge, I think what matters is what the court found, and then this court and the whole order was on appeal. What they decided to argue in their briefs or not argue in their briefs, I don't think matters to that point.
but we wouldn't go out and just find a new issue. You know, we're not looking at findings that you all might argue were incorrect findings or
Correct.
findings unsupported by evidence or, so if y'all don't challenge that, we're not just going through unless there's some, I don't know. I mean, I can't, in the case, in this civil case, I can't envision a situation where we would just go through and say, that finding was right, that finding was right. Like if it's not our role to go out and find those issues and determine whether we think they were properly made, regardless of whether you argue it on appeal, we're not really deciding that, right? In that way, in my mind, we're limited to what the argument was in the initial brief. And then, you know, if our court writes, well, as to that, we affirm, it's still in that box, right? It's cabined by the issues that are raised in the initial brief.
Respectfully, I think what you're limited by is the order, not what a particular litigant chooses to put in an initial brief or not. And what the court did, the finding, and if you look at the appendix at 18 through 20, you will see a finding by the lower court that Ms. Santangelo was indeed a surviving spouse entitled to her intestate share. That was affirmed by this court, by its order. That's what you're doing. You're reviewing the entire order. I agree you're not going out looking for other issues. No, they're right there in the order. And the question is, are you affirming those? Which I believe, well, I know you did.
But counsel, the only two issues raised in the first appeal were, is your opponent entitled to reformation, right? And can Ms. St. Angelo be the personal representative? Those were the only two issues raised. I know the order made other findings of fact and legal conclusions, but the only two issues raised were those two before this court.
Well, if you look at it that way, Judge, then to go back to Judge Ganem's question about law of the case, then if the issue of her determination as an intestate heir, as a surviving spouse, was not appealed, then it too was law of the case at that point in time. You know, nothing changes on that.
But isn't that contingent on rejecting Giuliano and accepting Wharton versus Washington, the second
No,
case?
it's contingent on final orders being final orders and being binding on the court, whether it's res judicata, whether it's law of the case. You can't change the final order. And that was the final order. And using the theory that that particular issue of the judge was not appealed, then it became a final order and was binding on the successive judge, which is the key point. The reason we are here on a more specific set of points, on the initial brief we discussed the due process provision and the fact that it's, although I gave you at your request evidence that would be presented, whether the quality of that evidence is important to this court or not is not an issue. The question is having the right to present that evidence and the closing argument.
Counsel, does your briefing, if you can just remind me, does your briefing walk through that evidence and say, you know, because sometimes we see like in a 1.540 motion where you need an evidentiary hearing, and I might be like misquoting that, and I'm sure there are exceptions that aren't coming to mind right now, but sometimes there's sort of like a blanket rule. And then sometimes you just need an evidentiary hearing because there's some disputed issue of fact, and therefore it needs to be resolved by the court, you know, at some evidentiary hearing. But in your briefing, did you walk through that and sort of articulate, well, okay, I've got a disputed issue of fact as to what the business is, for example, and that needs to be resolved in order to make this factual finding, which then bears on the conclusions in the case. And if you didn't do that, wouldn't it be hard for us to find prejudice, for example, or harmful error, or to make any assessment as to whether an error was actually committed by the trial court in failing to hold an evidentiary hearing?
Well, getting to your last point first, the unique problem in this case is we thought we were going to an evidentiary hearing that never happened. There was no point where the court said, okay, now we're having an evidentiary hearing, and here's what you can do and what you can't do. So without a record on that, there was nothing really to brief and nothing really to talk about on that other than the fact that we tried to have an evidentiary hearing and we were not allowed to have one. And what the case law says that is cited in our brief is that's the end of it. And by the way, this isn't about harmless error or not, because that involves questioning what evidence would be there and what wouldn't, and that's not the point. The point is it's a fundamental due process error.
But it's not always a fundamental due process error, right? Like if you don't have a dispute, for example, if you had a mortgage and say hypothetically that the question was whether she's on the mortgage and has some obligation to pay, right? The other side might not dispute that. And so you could just sort of check that box and move forward with your argument, and you wouldn't necessarily need an evidentiary hearing.
Well, sure. There's a stipulation. We want an evidentiary hearing. Well, no, you don't get one then because it's been agreed to. Totally get that. Absolutely. That is the case.
Thank you.
Counsel, you're in your rebuttal time. If you'd like to keep going, you may.
You know what? I'm just going to, I always watch judges talk about this, so I want to tell you what I want. And if that goes into the 5 minutes, then that goes into the 5 minutes. Based on our initial and reply briefs and today's discussion, we ask that the court reverse the 2 orders under review and remand for an evidentiary hearing with instructions that Carla Santangelo has standing as the holder of an intestate share of her husband's estate, and then instruct the court to proceed with the evidentiary hearing on the 3 petitions. Thank you. 3 minutes left, maybe?
3 minutes, 37.
Okay.
Counsel, whenever you're ready.
Good morning. May it please the court. I'm Steve Sen, counsel for the adult children of the decedent Daniel Santangelo. This is the 3rd appellate review by this court of the administration of Mr. Santangelo's estate. The first one we've talked about was an appeal of two issues, and one of them was reversed and the other was affirmed, and it was sent back to the probate court for further proceedings. In the course of those further proceedings, there was a lot of argument about what did the 6 DCA mean in that first panel, and how should the probate court wrap up the other issues that had to be wrapped up consistently with the guidance that this court provided. And in fact, the probate judge asked the parties to submit memoranda on what was previously decided and how that governed what would go further. The wife was unhappy with the resolution of some of those decisions and came back to the same prior case with a motion to enforce the mandate. And in that motion to enforce the mandate, the argument was made that these subsequent decisions were law of the case. Now, we said, well, you can raise an appeal if you want. This is probably not the best way to do it. But this court didn't dismiss it. This court denied the motion and basically made, and that is a decision that itself is law of the case. And so as to the law of the case issue, law of the case is against the wife's position that law of the case is in her favor. This court has already decided that these subsequent decisions do not violate law of the case when it denied her motion in that regard. So that issue, we think, the law of the case issue, is ironically barred by law of the case. Here on the, and that was a correct decision because it was that those issues had not been raised in the prior appeal, and the Giuliano case, as well as the Delta property management case, more recently made clear that these decisions that were not, anything that was not actually raised on appeal and addressed by the appellate court is not law of the case. As to the due process issue, that was never raised in the trial court, and we've heard the explanation that, well, you know, we got this order and we never had an opportunity to present evidence. But the whole theory of an appellate court is that you are reviewing decisions of the trial court for legal error. And in the absence of the decision, you generally don't have anything to review. Here, there was no decision by the trial court. They was never asked to consider any evidence, was not proffered any evidence in the trial court. No argument was made as to what that issue would be relevant to. And so you're here asking to review something that happened that the trial judge did not have anything to do with. With regard to whether that might have been raised after the fact, well, this court and the rules have developed such that when you get an order that has what you think is error, that had not previously been part of your arguments at that level, then you need to give the judge a fair chance of hearing your arguments and letting the judge decide it. And I would argue that that's especially the case with regard to evidentiary issues, where review is for abuse of discretion. And here, there was no argument, not in the trial court and not in the appellate briefs. Here, for the first time today, we are told that it may have been relevant to this Okeechobee Outfitters issue. But there's not been a dispositive ruling by the trial court on where Okeechobee Outfitters is going to go. There is a pending motion that has not yet been set for a hearing. So they will have the opportunity in subsequent proceedings in the administration of this state to present whatever evidence in front of the probate court they think is relevant and appropriate to that issue. The issues here, it's two issues, but the primary issue of whether the wife, there's two issues. One, should there have been evidence admitted to show that the wife should have received this property free and clear of a mortgage? That's just a straightforward application of the plain terms of the antenuptial agreement. And under those plain terms, it didn't say, and the probate judge said that he was specifically enforcing it, but it doesn't say she gets the home and 5 acres free and clear, or that the estate must pay off any mortgage on it. It doesn't say that. And so that would be any evidence to try to change what the document said, what the agreement said, would be in violation of the parole evidence rule, and would not be, even if the issue had been raised, the judge would have been well within his discretion to disallow that evidence.
Counsel, let me, if I could stop you there, while we're on the subject of interpreting paragraph 3.07 of the prenup. Apart from that language about devising the marital home, there's a language that precedes that, which I understand your clients tried hard to get reformed to read that basically, each party can dispose of by will whatever they want, but in the absence of that, then the property will, say, I'll just read it. The estate of each party shall descend to the heirs of that party. You wanted it to say as if the marriage had not taken place, which would have meant one thing, but that wasn't successful. So we have the language that we have, and it says the estate shall descend to the heirs of that party as if the marriage had taken place. What are we supposed to do with that language now, understanding that that's what the contract says? How do we interpret that? What does that mean?
Well, I'll tell you what the probate court did, is he said we need to look back at what the 6th District said, which is to look at the more specific waiver of all rights earlier and find that governs, because the language that you're referring to does not specifically say that the wife can take an intestate share. And in 3.01, the parties do hereby waive and release all rights, including the right to any distributive share. So if you're trying to figure out what that admittedly confusing language means, whatever it means, it has to be harmonious with the very specific waiver of a distributive share of the estate in 3.01. That's what this court did in the first panel opinion, is you said, okay, we see this back here, but these waivers up here have to be enforced, and when you do enforce those more specific waivers, to the extent that they aren't expressly restricted by 3.07, then in that case, the court found that the probate court erred in appointing the wife to be the personal representative of the estate. The arguments to the probate court below were that you apply that same analysis, and if you apply that same analysis, then you get basically the same result. 3.01 governs because it is by far the more specific language dealing with that. And there was nothing in the prior decisions of this court or the prior decisions otherwise to the contrary. Now, this argument that there was some kind of dispositive finding earlier on that she was entitled to an intestate share, if you look at the orders, it doesn't really say that. It says that she may make a claim.
I'm going to back up and go back to the language again, because I understand your argument, and assuming that we interpret our prior decision in this case, where it says that 3.07 at most simply revives the wife's right to take under the laws of intestacy. Your argument is it doesn't even do that. And so if we have some obligation to read all the provisions to give effect to everything and to avoid as much as possible, superfluous language, what should we construe that language to mean? If it's not to reinstate her right to an intestate share, what does it do?
Respectfully, Judge, that issue is not before you. We are here on the two issues that have been raised, law of the case and due process. There is not a general appeal that the trial court erred in his construction of the agreement. That is not one of the issues that's here, and I don't think it would be appropriate for the court to consider an issue that nobody has raised. It was all argued certainly at the probate court, but here we've got law of the case, which we've talked about a lot, and due process. And unless one of those two things was reversible error, then this court should affirm. On the due process issue, that was never argued below. That's being raised for the first time on appeal. And as we argue in our brief, there was no due process violation for the simple reason that you don't get to just present evidence without limitation or restriction. There's lots of rules that govern it. Generally, for due process to give you a right to introduce evidence, there has to be a disputed issue of fact that is relevant to the outcome of whatever relief somebody is seeking. And we did not hear until today what issues might be presented. And quite frankly, as to those issues, those weren't decided yet by the probate court. Okeechobee Outfitters is still in play, is still to be determined by the appellate court, and we would urge the court not to address issues that have not been raised in the briefing. Particularly, I mean, you certainly can do that to affirm, but you particularly should not do that to reverse. So issue 1 is not preserved because the probate court never issued any ruling excluding evidence, and issue 2 is barred by law of the case based on this court's prior denial of the motion to enforce. We have other issues in our briefing, but I believe those points should be adequate to affirm the decision of the probate court unless there are other questions from the court.
I do have a question, counsel, about your application for attorney's fees. Looking at Townsend versus Manfield, can you address whether this court has the power to grant you attorney's fees in the probate matter?
I think not. We did it in an abundance of caution, and we kind of reviewed the law about how that developed. It was in the Constitution, and then it was out of the Constitution, but it's still by statute. And then I think this court has a precedent on that, which when we moved for fees after the court denied their motion to enforce the mandate, we had a motion for fees on the motion to enforce the mandate. And we filed very similar motion there, which we talked about the uncertainty in the law, and this court issued an order, and we have filed that in this case. It was issued under the other case number. Filed that in this case where you basically deny it without prejudice for the probate court to consider. And I think that's the best answer, but given the uncertainty in the law, and at the time we did our prior motions, we didn't even have that. So but that's what we think the right answer is to deny that without prejudice and allow the probate court to address it. If there are no other questions, I thank the court for your attention.
So what I'm learning is everything's okay because all of my client's petitions are still in play. The problem is her standing, and that is her intestate share, which she must have, and which the court denied, even though there are 5 orders that say she's entitled to it. And I disagree with my learned friend about those orders being vague, particularly the order on rehearing. It clarifies in precise terms that she's entitled to her intestate share as a survivor spouse. court did that again with respect to the family allowance and exempt property. So to say that it was vague is just not accurate. Now,
So you dispute that it simply said that she could challenge it later, or they would address it later, and you think that an express finding was made in that regard?
in the rehearing that was never appealed, and in the exempt property order that was also never appealed. 100% precisely. If it was vague at all in the prior ruling, it was not on rehearing. Please read those orders. They are part of our appendix because they could not be more clear. As vague as the other one might have been, these are crystal clear.
Counsel, your colleague has described your initial brief as really focusing on law of the case instead of the trial court's substantive ruling.
Yeah.
I share that read. Am I wrong? Have you challenged the substantive ruling of the court on the interpretation of the antenuptial agreement when it comes to her intestate share?
No. What I have done is argued, again, that we were entitled to a hearing on all of this, an evidentiary hearing, and to say we didn't preserve it. We did what one must do. We did a notice specifically of an evidentiary hearing that never was permitted. We were not in a position to be able to address that. I wanted to come back, Judge, if I may, to the argument about the enforcement of mandate and the court's denial of that motion as somehow being significant here. The enforcement of a mandate, as this court knows, is a simple juxtapose the mandate with the ruling, and on a ministerial fashion, was it effectuated by the lower court. That has nothing to do with the due process arguments. That has nothing to do with the rehearing order that was never appealed. It's not part of that case. It's nothing to do with the family allowance and exempt property issue. Nothing to do with any of that and the pending petitions. There's some sort of argument that we should have done something more, and this is just in all the cases they cited, for example, on the proffer of evidence. There was an evidentiary hearing where objections to evidence were sustained and nobody proffered evidence. That's not this case, because we waited for an evidentiary hearing and it never came. Did we somehow, which they say in their brief, we needed to raise that in rehearing? Not in a non-jury case. 1.530 is crystal clear on that you have the right, but you are not required to do that to preserve an argument. Uniquely, in this case, 1.530, I think, does apply because our petitions relate to determination of beneficiaries, which is a term of art under 733.105, and all of our petitions qualify for that. So those are deemed adversary under Rule 5.025. Thank you for your time. I see I'm out of time. Thank you.
Thank you, counsel, for your argument today. No need to rush. I'll go ahead and call our second case, and they can come up at their leisure. It's Lee County, Florida versus Captiva Civic Association, Inc. and WWSSI.